the appeal of Tafari Morrison against the King.
Now, Mr. Southey, there's a matter of what one might describe as housekeeping that I have to raise with you, but it's quite an important one. Your arguments introduce a number of issues that weren't canvassed in the courts below. And you haven't applied to us for permission to introduce new issues. I'm thinking in terms of the provisions in the Constitution that are relied on.
Well, my Lord, to the extent I need to, then I apply for permission to do that. They were clearly canvassed in our grounds of appeal, and obviously the grounds of appeal resulted in a grant of permission which was unopposed, in fact. And clearly, I think all parties are, from the written arguments, ready to argue, as I see it, those points. Clearly, it would be unfortunate if a matter of this importance didn't consider all relevant provisions of the Constitution.
Well, in a way, that's our concern, that the Court of Appeal of Jamaica itself has an important role to play in appeals on the Constitution. And they were asked to look at, I think, 13.3K, 13.6, 13.7. But they weren't asked to look at other provisions of the Constitution which we're being asked to rule on. And there's an issue as to whether it's appropriate for the board to issue judgments on articles of the Constitution in a situation where the Jamaican courts themselves haven't had an opportunity to give us their views.
Well, one of the difficulties may have been that, of course, the approach of the Jamaican Court of Appeal was to primarily rely on the savings clause as an answer to the points being made. Of course, it's now, in any event, conceded that the savings clause wouldn't apply in this context.
Well, it wouldn't save the mandatory character of the...
It wouldn't save the mandatory character, and obviously the focus of this challenge is on the mandatory character. So even in relation to the relatively narrow points that might otherwise be sort of which would otherwise be before the court if one didn't go beyond the issues now raised, even in relation to the
but obviously 13.7 could only come into play or be relevant if there was otherwise a breach of some substantive article of the Constitution, and as I say, the candidates that were considered by the Court of Appeal were more limited than we're being asked to consider.
Well, yes. I mean, I was reminding myself again of the appeal notice, and of course the appeal notice is that was filed in the Jamaican Court of Appeal is what I'm referring to. The appeal notice simply referred to the Charter generally and the Childcare and Protection Act. Now,
the only provisions that were actually raised in argument were, I think, 13.3K and 13.3.0, which feeds through to 13.6 and 13.7. Is that not right?
That seems to have been the case from the description of the argument.
Then we're back to the point that my Lord has raised, that it wasn't the other constitutional provisions you tried to rely on before us weren't even raised before the Court of Appeal, and the board places great weight on the assistance it receives from mature consideration by the local courts of provisions of the local constitution.
Yeah.
How can we proceed, de novo, the point not having been even raised in the Court of Appeal, and where we don't have that usual assistance that we would expect, for good reason, to have available to us.
Well, my lady, the primary concerns we would have in relation to that are, firstly, obviously, this is a young man who has now already spent a considerable period of time in custody. I mean, that's obviously, from a personal point of view, but from the appellant's personal point of view, that is a key factor. Remittal is likely to cause significant delay, and we would point to the fact, as I say, the notice of appeal, although I accept in oral argument the focus does appear to have been on the, as far as we're aware, on the specific provisions that have just been put to me. The appeal itself was more generally about compatibility with the Charter.
Mm-hmm. Yeah. Well, you understand our concern.
My Lord, can I just say that the position also may be slightly more complicated in the sense that if one looks at the judgment, one of the features of the judgment, when it looks at, I think it's the South African case law in particular, is that it does refer to the differences between the Jamaican Constitution and the relevant provisions of the South African Constitution, because the South African Constitution has more specifics, as we would probably put it, about the rights of children. So it had in mind those provisions and effectively relied on the absence of provisions equivalent to the Jamaican, provisions equivalent to the South African Constitution. And obviously our position is that through the provision in particular, I think it's 13H from memory, that deals with children, those similar standards in fact are imported.
I think children is K.
I can't remember off the top of my head. I'm surprised I'm talking off the top of my head.
33K was certainly raised in the Court of Appeal. I mean, obviously, there's no problem about your arguing points within the scope of the arguments that they heard. But the relationship between this board sitting in London and local courts in the Caribbean is one where we have to be conscious that we are interpreting the Constitution, in this case, Constitution of Jamaica, and it's not, on the whole, a good idea for this court to embark on the exercise of ruling on the scope of constitutional rights in relation to Jamaica without any input whatsoever from the courts of Jamaica itself.
Well, the difficulty, in one sense, and this may be why we're not as express as we might have been about this issue, but the difficulty in one sense is that the Jamaican Court of Appeal in this case, and it's why I made reference to that South African, the approach to that South African case law, the Jamaican courts were clearly conscious of the full provisions of the Charter. And if, in one sense, we were to proceed on narrow basis, our position in any event would be, because this is the approach effectively of the Inter-American Court, and the Inter-American Court are interpreting effectively the same language, because the language of the Charter reflects the language of the Inter-American, not the Inter-American, the American Convention. The approach of the Inter-American Court is quite clearly to regard the child provision as being effectively the input, in summary, and there's obviously a little more nuance than this, but in summary, as applying effectively an enhanced standard to the other provisions of human rights that are protected.
But we're saying you can raise the child provision.
Well,
it's just not the other provisions that you refer to.
Well, my Lord,
it's K, 33K, well, 33, which plainly were raised.
If we can raise the child provision, I mean, to be frank, the child provision, and in the context of when supplemented by the inhuman degrading treatment, takes one a long way.
You may be right,
yeah,
but
yeah.
We have a concern, which my lord has already expressed, about our relationship with the local courts and the benefits we get from consideration of matters by the local courts. We also have a concern to maintain, useful and proper focus for an appeal before us. Your written case seemed to range far and wide over provisions over which we've had, which weren't raised below and on which we've had no assistance. For my part, it seems to me it may maintain better and more useful focus for us if the focus is on 13.3K and 13.3.0.
Well,
I don't know if my colleagues...
the other difficulty...
In practical terms, you say that those provisions, I think you used the word, they enhance the other protections, and would you agree that if you don't manage to persuade us by reliance on K and O, you're unlikely to succeed relying on the other provisions that you referred to?
I think that's probably right in terms of the sort of them as freestanding. The concern I have, which is what I was about to come back with, is in one sense one needs to, which is one of the reasons why they're there, one needs to potentially look at the Charter inevitably as a whole. And so, for example, the initial provision, if I remember rightly, which refers to human dignity, is potentially of some importance, because that reference to human dignity, which is then reflected in, I think it's 13H, might be said to echo in some of the instruments that then deal with the rights of children, because we would certainly argue that one of the reasons why children are treated differently is that part of treating people with dignity is recognising that individuals have particular characteristics, and obviously for children those characteristics are clear.
Yeah.
Sorry, just you're referring to dignity. I hadn't picked up reading the Charter.
Maybe I'm talking from memory again. So, but I think if
in a sense,
yeah,
you can cut through this. If you've got essentially what you need for your argument from 13.3K and 13.3.0, clearly those provisions were raised, and we can focus on those.
Well, yes. I mean, we they are I would accept the key provisions, and as I think my lady put to me, if I'm not going to win on those sorry, the reference to dignity, if one goes to I hadn't misremembered, if one goes to 13.1b.
Yeah. Yes, on page 239.
Oh, I'm so sorry. Yes.
Sorry, and it's 296 is the original. 239, 296. Can I just indicate? I think the parties, there isn't an official consolidated version of the Constitution that anyone's been able to identify. That's why we've used the Constitute Project document, because it seems to be the only consolidated version. And I think all the parties are agreed that, both parties rather agreed that is something we can refer to. So that's why I was using the 296, because that's the consolidated version of the Constitution produced by the Constitute Project.
Yes. It's probably my fault again, but I hadn't picked up in your written case a reference to 13.1b, which may be why I hadn't focused on that. Can you point us to that?
I will.
I've noted down a range of other constitutional rights you referred to, but not that one. But that could well be a mistake on my part.
It may not be. It certainly should have been. But,
Well, I don't want to take up more time than we need to on this. If you can't pinpoint it, we can, in a sense, all look for ourselves, or your junior can give us the reference at some point.
Yes, I'll ask my learned junior to deal with it. But as I say, I certainly would accept the point put to me by my lady that the key principle, the key provisions are the ones.
Well, can we proceed on that basis then?
Okay, thank you.
We're much more comfortable to do that.
Can I also just raise one thing as well, given that we're sort of raising the issue of housekeeping? In our written case as well, partly because of the approach of the Court of Appeal, we did address at length the savings clauses because they were obviously something that featured heavily in the Court of Appeal. You will have seen that my learned friend on behalf of the respondents makes a concession that the savings clause doesn't actually apply in this case because of the nature of the challenge, which is to the mandatory minimum. I can address you because obviously the Court of Appeal reached a different conclusion on that. Equally, if that's not going to assist, I don't want to spend time on something.
No, well, unless any of my colleagues feel otherwise, I think the reasoning in Hughes obviously has a bearing on this, and if the parties are agreed that Hughes effectively means that the mandatory character of the sentence isn't saved by 13.7, then for myself, I don't feel any need to be addressed on it. I don't see any signs that my colleagues want to be addressed on it.
No, well, I thought that might well be the case, but I am ready and able to address you on it should that be necessary. Can I then turn to the substance of our argument? This obviously is a challenge to the mandatory minimum sentence of 15 years that was applied in the case of the appellant. It was applied in the case of the appellant when he was a child and in relation to an offence committed when he was a child. Now, I emphasise the child focus of that because the respondent in our submission does, to some extent, focus on the approach to sentencing adults, and so, for example, cites Canadian case law in relation to that. There may be arguments about the imposition of minimum sentences in the case of the adults, but that is clearly not what our case is about, and that's not how it was. That is one area where we've sought to reflect what happened in the Court of Appeal. In our submission, children are different, and that is the important starting point. Now, with that in mind, the structure I'd like to adopt in my submissions is first take you briefly through the factual background, then briefly through the provision in issue, a little more, perhaps in a little more depth, the Constitution, then go on to the principles to be applied interpreting that, then look at some of the relevant human rights instruments and the case law regarding those human rights instruments. In that context, or following that, I'd then like to look at briefly why children need to be treated differently and material that demonstrates that, and finally finish with submissions trying to bring all of that together effectively. Turning to the factual background, the background to this, as is clear from the trial transcript, which is at page 43 of the bundle, is that on the 10th of April 2013, the appellant pleaded guilty to 3 offences. And count 3, an offence of wounding with intent, was one that there is no dispute attracts the statutory minimum sentence. Having pleaded guilty, a social inquiry report was prepared, which was dated the 3rd of May 2013, and that's at page 49 of the electronic bundle. That recorded how the appellant had been expelled from school, age what would appear to have been, if my maths is correct, between when he was either 14 or 15, given his date of birth. he received no emotional or financial support from his father, although his father was lived a few houses away. It's page 50. He did provide support for his mother, who was blind and also couldn't walk. That's important in our submission because it is evidence of good character, and it suggests the potential we would submit for rehabilitation. At page 52 of the bundle, there is a reference to a community reports, and that records how the appellant's neighbours had noted support for the mother, and the neighbours had also commented on negative peer influence. That might not be surprising in the absence of the father, but it's important.
It says here on 49, the father is unknown, address unknown, occupation unknown, but you say lived nearby.
Well, if you go over to, that's the reason I got that, the place I got that from is if one goes to page 50, under the heading Early Life and Family Background, first paragraph there, one sees in the second and third sentences, it's the third sentence in particular.
Yes, thank you.
That's where I got that from. Whether we'll see. And in one sense, though, it may not matter hugely. The critical point is that the support is non-existent. Apparently, that's not. So I was referring to the issue of negative peers, and that's significant for two reasons in our submission. Firstly, it's consistent with one of the points that is made in a number of materials that consider the specific position of children, which is that children, because of their lack of maturity, are more open to influence by others. Secondly, again, it's an indication that there may be a significant prospect of rehabilitation. The sentencing hearing took place then on the 10th of May 2013, and that's the transcript of that is at page 53 of the bundle. And it's clear from that that at an early stage, the mandatory minimum was going to determine the sentence. So, for example, at page 58, one sees at the top of the page counsel highlighting the significance of the guilty plea. And that was met by the trial judge at page 8, at line 8 rather, pointing out that there was a mandatory minimum.
And as I understand it, in fact, at that stage, the constitutional rights were not being argued.
Exactly.
I mean, that doesn't foreclose you, just to be clear, because certain ones were argued in the Court of Appeal, but just so we're clear on the facts, no reference to the Constitution.
No reference to the Constitution. I mean, to be frank, it's slightly unclear how. Well, counsel then does appear to recognise that the amendment, so and the fact that there is a mandatory minimum, but clearly it didn't focus very heavily in terms of argument about the sort of how that could be departed from potentially.
But this was all before those amendments which allowed the judge to give a certificate.
Yes.
So
yes.
Those provisions didn't apply.
Absolutely. Absolutely. They were enacted, I can't remember the exact date, but it was 2015 and this was 2013. What counsel did do, page 59, it is try and identify some of the things that we would submit potentially need to be taken into account if you're sentencing to take account of the best interest of the child, which is the potential for, to use the language of the mitigating remarks, he referred to the potential for redemption and the potential for rehabilitation. The judge's sentencing remarks are at page 62 and 63, and the judge noted that there would normally be a need to discount for a guilty plea. But the statute effectively prevents account being taken of that. It also the judge also refers to the fact he would normally have taken account of the appellant's, to use his language, tender years, but concludes that he was bound to impose
it prevents it from being taken into account insofar as it might reduce the sentence to less than 15 years. But if the sentence without a guilty plea was going to be 25 years, then you could take into account a guilty plea.
Absolutely.
Yes, so there's no separate provision saying for this a guilty plea.
No, but I mean, clearly, what I would submit, which is consistent, I think, with what my lady is putting to me, is what the trial judge seemed to be saying was that I would normally have reduced, implicit is when what he's saying is I would normally have reduced below 15 years to take account of these things, but I can't because of the 15-year minimum. I mean, if the judge was thinking of, say, 25 years, it would have been open to him to say, well, I'm not really bothered by the minimum because I would have imposed 25 years, but because you're a child, I'm going to, in fact, impose a 20-year sentence. But that's clearly not what he's doing, because he goes through these points about age and guilty plea, and then ultimately says, but I can't do anything about those because of the 15-year minimum. So, but my lady's right, of course, that if it had been a 25-year sentence, 25-year starting point, the problem wouldn't have risen. The Court of Appeal obviously then considered the matter, and given the points that have been made to me, I've got no doubt that this court is very familiar with what the Court of Appeal said. And obviously, the starting point, in one sense, was that the trial judge had erred because he'd applied the minimum to everything, and it's only count 3 that the minimum applies to. And so the structure, obviously, of the judgment is that it starts by noting that error. It then goes on to consider the Constitution.
Before we get on to the Constitution, if there had not been a minimum sentence required legislatively,
Yes.
what is the relevant provision setting out the Court of Appeal's powers on what I would call an ordinary appeal against sentence? And is the test that they apply manifestly excessive?
I don't think we've got that in the bundle because of the nature of the arguments, but can we come back to you on that? We'll get that from you.
I would like to know at some stage,
Yeah.
What is the difference between manifestly excessive and grossly disproportionate?
Well, manifestly excessive, sorry, if my lord means the powers to... Manifestly excessive, if I remember rightly, is obviously the language that is used in the new, the amendment, the 2015 amendment.
No, I'm thinking about the ordinary test,
Right.
which would be applied by a Court of Appeal in this jurisdiction,
Yep.
whether it is applied by the Court of Appeal in Jamaica.
Yes.
And then what the difference is between the two tests.
Yes. We'll come back to you in relation to that. I mean, in one sense, as I say, the reason we have very much focused on the issue of the mandatory minimum, because the mandatory minimum clearly influenced both the trial judge and the Court of Appeal. The Court of Appeal ultimately reached a conclusion as to the sentence they would have imposed but for the mandatory minimum. which was less than 15 years. So again, there's no doubt in our submission that the Court of Appeal were constrained by the statutory mandatory minimum, but we will come back to you on that, my Lord Ifham.
But when they looked at the sentence, leaving the mandatory minimum to one side, they appear to have looked at it from the point of view of three tests. One was grossly disproportionate, one was proportionate, and the other was manifestly excessive or burdensome. And the question is there a distinction between those? And which of them applies in the context of 13.6, if any?
Well, my Lord, can I answer that first? I'll tell you what our position is in relation to the final, that final question first, because that may assist. In the case of an adult, we would accept the 13.6 is grossly disproportionate. In the case of a child, we would submit that the position is more nuanced in the sense that when the test may not change, but fundamentally, when looking at whether something is grossly disproportionate, a court needs to take account of the special position of the child, and in particular the need to take account of child welfare factors.
So that's exactly the same test. That's the same test, grossly disproportionate. But in determining what is grossly disproportionate, you take into account both the offence and the offender, and the offender will differ. And so the test is the same. Are you accepting the test of grossly
We're accepting the test, but the point I'm making is that in relation to a child, what we're saying is that if you don't take account of the best interests of the child, and so that is ignored, that is grossly disproportionate in the sense that is grossly disproportionate, has to be influenced by international human rights standards, and the best interest of the child is a fundamental principle.
All right, just to be clear, in the case of an adult, 13.6 also applies.
Yes.
And is it the case that in respect of an adult, you say there can be a sentence which is manifestly excessive but not grossly disproportionate? In other words, that 13.6 will only save the grossly disproportionate but will not save some of the manifestly excessives? Or how do we deal with the language issues here?
As I think we point out in our written case, my Lord Reid made the point that one of the problems that potentially arises in relation to human rights law is that human rights standards are often expressed in broad terms, and domestic law has to fill in some of the gaps. So if as a matter of domestic law, a manifestly excessive sentence is unlawful, we would submit that by definition must mean it's grossly disproportionate, because effectively that is how...
But what's the difference between grossly disproportionate and disproportionate then? I mean,
Well, in one sense, the difference may be this, in that as a matter of domestic law, where manifestly excessive applies as the test, one is the use. Why does manifestly matter? Manifestly matters because what the court is seeking to do is recognise that although it may disagree with the sentencing judge, may think that the sentencing judge was a little harsh, that's not the basis on which it intervenes. It intervenes when the sentence is outside a sort of acceptable range.
Yeah, I mean, it isn't usual if you're finding a sentence to be manifestly excessive that you're concluding that the judge has imposed a sentence that is cruel and inhuman.
One isn't, because one's not going to... One doesn't need to turn to the convention because that's what domestic law applies.
No, it's not about terms, it's about reality. It's not contrary to Article 3 of the convention in virtually, I imagine, possibly every case.
Well, my Lord, the reason why I was submitting that it might be is simply this: it is that if you if a domestic court imposes a sentence which is in fact unlawful, what it is doing by doing that is failing to give the person the rights they're entitled to as a matter of domestic law. And in that in that way, effectively failing to recognise humanity of the individual. But I'm not, in one sense, I'm slightly concerned about going down this route in too much detail because of the fact that it goes back to the point I started with, which is that we're talking here about a specific issue, which is the position of children. And in relation to the position of children, we do submit that the standards in any event are higher, as is recognised in the Jamaican Constitution.
You don't accept that. You say the same test applies, but you take into account the fact that the person is a child.
Well, you take into account the person as a child, but that is importing then a higher standard, a sentence.
Import a higher standard. It just means that when you apply the standard, you take into account a particularly relevant consideration, namely the person as a child.
Well, my Lord.
What is the standard then in relation to a child?
Well, the way I would put the way I think I put it a moment ago, and the way I would put it now is that when you consider the question is whether or not, in relation to inhuman degrading treatment, the sentence is grossly disproportionate. In that context, one needs to recognise that a child is different, and because a child is different, one way of putting it is that what might be perfectly compatible with the protection against inhuman degrading treatment in relation to an adult is not in relation to a child. And that's why I'm saying the standard is ultimately different, because you
Surely, analytically, the standard's the same, but as my Lord says, there's relevant factors have to be taken into account. I mean, in working out whether something is grossly disproportionate, you have regard to what would have been acceptable and then compare with what you have in fact got. And it seemed to me that at one point, at any rate, you were putting it in terms of, well, when you're sentencing a child, you would expect the ordinary sentence, all things considered, to be less, and therefore the gap between the sentence in fact imposed and what should have been imposed is that much greater. So it may well be easier to say that there's a gross disproportionality in the child case, but it's still a test of gross disproportionality.
Well, my thought that might be illustrated by the fact that children are not a uniform category.
No.
You can have a child offender who's 10 years old, you can have one who's 17 years old, and the courts, his 17-year-olds are what were once described to me as the core customers of the criminal courts. And courts are going to treat a 17-year-old more like an adult than they're going to treat a 10-year-old. Yeah, it's obvious common sense.
Absolutely, but that's one of the reasons why, in one sense, what we're saying about the sentencing of children is that, in relation to the sentencing of children, a mandatory minimum is, we would say, unconstitutional, because you need to take account of the individual circumstances of each child. That doesn't mean you can't impose a 15-year sentence on some children in the right circumstances, but that's why, going back to the point I made about which dealing with my Lord Sale's question, I think is important. We would submit that because of the need, and it's one of the reasons why I was sort of trying to put our position about grossly disproportionate in the way I was. We would submit that if a sentence is imposed which fails to take account of child welfare, given the importance of that, and obviously child welfare is not like a trump card, doesn't mean you can't be sent to prison or can't be sent into custody. But if there's a failure to take account of that, that does amount to something that's grossly
It
disproportionate.
doesn't necessarily. If a sentence is imposed which failed to take into account child welfare issues
Yes.
and resulted in a grossly disproportionate sentence, then it would be unconstitutional.
Well, my Lord, the reason I was going as far as I was, which was beyond what was just put to me by my Lord, is that one of the we would submit the question that's always potentially raised by questions of proportionality is how does a court assess proportionality? And if there's been a failure to comply with basic human rights standards, key human rights standards, in our submission that does bring into play proportionality, and that's why I was saying that if you don't take account of child welfare, that becomes grossly disproportionate, that sentence, because it's a sentence which is imposed, not just
Take Lord Reed's example of a child who is 17 years, 11 months of age, and nobody pays any attention to the child factors, and imposes a sentence, a minimum sentence. You would have to ordinarily you should discount, but not as much as for a child of 10 years of age.
yes.
Well, the sentence imposed on a 17-year-old in 11 months may very well not be disproportionate or grossly disproportionate, despite the failure to take into account the fact that the person is a child.
Well, the difficulty with that, which is one of the reasons why I take the position I do, is that, of course, without that assessment of what child welfare requires, it's difficult to know what the influence of child welfare will be. I mean, age is one thing. The fact that somebody is young is obviously a factor that's taken into account partly because the individual will have a lack of maturity, but it's not the only. I mean, the child who's just on the cusp of being 18 may be able to point to the fact that there are factors in his or her background that demonstrate that they are much more likely to be rehabilitated than an adult, and that as a result a sentence which is intended to facilitate that rehabilitation may be appropriate.
Well, in light of the concessions that have been made in this court, I mean, and the objective here is to find a formulation to assist the courts in Jamaica in terms of the correct approach to sentencing in these cases.
Yep.
So this no longer is a strict minimum sentence in the sense that it's agreed that is a minimum sentence in respect of which the court should intervene where the proposed minimum or the minimum is grossly disproportionate. Right?
I'm sorry to intervene, but I was just going to push back against that that idea. You need to persuade me of that, because we're not talking. We haven't so far used the normal language of inhuman and degrading treatment in the context of Article 3 at all. You know, where you speak about how the treatment must attain a minimum level of severity, and how you have regard to the motives of those involved, and so on. For sort of, I mean, you refer to T and V in your case, and that's one of many illustrations. Well,
can I also just make one point also, I think, at this stage, which is that and it's perhaps important not to lose sight of this. I made the point, and I'm not resigning from this, that 13.3K influences the approach to inhuman degrading treatment. But 13.3K is also a statement of rights. It's, on the face of it, it is not restricted to inhuman and degrading treatment. And one shouldn't lose, I mean, if I am wrong that a sentence in relation to a child that does not take account of child welfare is not a violation, or if I'm wrong that there is a violation in those circumstances of the inhuman and degrading treatment provision, we would say 13.3K in any event prevents such an approach, because 13.3K is not limited to 13.6. It is a general statement of the rights of a child, and so I mean, what I've been trying to do, obviously.
Sorry, if you're going down that route, what do you say is the standard to be applied if one's just looking at section 13.3K? Because I mean it's page 242. I mean, it's not fashioned by reference specific to the specific topic of sentencing. So one needs to do some work to spell out the standard that's then to be applied to, in the sentencing context, to identify a breach of this constitutional right. What I'm just asking for the submission. What do you say is the test to be applied?
Well, the approach to it, can I put it slightly differently in my answer, but the approach to it is this, that language reflects, and this is something I said a moment ago, reflects in particular the language of the American Convention. And the American Convention has been held by the inter-American bodies to import considerations such as the requirement to consider the best interests of the child. So it imports...
So are you saying, even if the resultant sentence given is correct, or even low, if the sentencing court did not go out of its way to consider the best interests of the child, that low sentence is nonetheless unlawful?
Well, it depends what you mean by low sentence in one sense.
Right, half what a child of that age would usually be given when being sentenced for this sort of crime.
But in one sense, that with respect to my lord, that's maybe the wrong comparator, in the sense that the correct comparator potentially ought to be how you would deal with a child who faces the same sentence, who has the same welfare needs. I mean, if in fact you give a child a half the normal sentence, and perhaps unusually in that context there are no identified welfare needs, well then the failure to consider the best interests of the child may not be material, I suppose, is what you're really saying. But if you give the child a relatively lenient sentence, but there are still welfare needs that are potentially should potentially influence the sentence, it's very difficult to say that that's not then material.
But suppose this had happened. Suppose this constitutional issues had been raised before the trial judge, and the trial judge had said, yes, I agree with you that the imposition of this minimum mandatory sentence for this Section 20 offence is a breach of the rights of the child protected by 13.3K, and I am therefore going to disregard the statutory minimum and will sentence as if the statutory minimum wasn't there. And then he imposed a sentence of whatever amount. Now, that could have been appealed on the basis, as my Lord Stevens was saying, of it still being manifestly excessive under the ordinary test that is applied, as you described, by an appellate court, bearing in mind it's not simply that the judge got it wrong, it has to be outside the reasonable range. But your case is, I thought, that that is what the judge ought to have done. And if he had arrived at a 15-year sentence, then that could have been challenged on appeal in the ordinary way. But I thought your case was that any minimum mandatory sentence is inappropriate and unconstitutional when applied to a child because it doesn't take into account the right of the child to measures of protection required by virtue of his or her status.
Well, that is, our position is, and it goes back to the point, that's why I was referring to 13.3k in one sense and the potential rights from 13.3k. This is what the fundamental objection we have, or the fundamental challenge that we make, rather, to a mandatory minimum, is that the mandatory minimum, on the face of it, prevents account being taken of the best interest of the child. It sets certainly, at least in cases where the sentence wouldn't otherwise be very high, very high. Not this case because of what the courts below found. But I mean, going to the hypothetical my lady put to me, I mean, if the trial judge had in fact said, effectively, I'm going to ignore the mandatory minimum, we would still say that the Constitution, because this is, if you like, the basis of it, the Constitution requires account to be taken of the best interest of the child. If the judge was to say, on some basis, I don't need to apply the minimum, but I'm not going to treat you as a child, I'm not going to take account of child welfare issues, that would still be unconstitutional, but and potentially appealable on that basis. But that's obviously not what happened in this case.
So I'm still trying to get a grip on what you say is actually the test if one looks at 13.3k as a distinct constitutional right. As I'm understanding what you're saying now, you seem to be saying that this is a right as to procedure, not as to result, and that if something has gone wrong with the procedure, even if the result is actually ordinary and completely acceptable according to the ordinary run of things, hence my putting to you, you might get lucky with your judge, to put it crudely, and he comes in with a low, what would be regarded generally by 9 judges out of 10 as perhaps a low sentence, but you get that benefit. But the judge has not gone through a process or a sufficient process of having regard to child-centred factors. As I'm understanding it, you're saying that would be a breach of, that would involve a breach of the constitutional right in 13.3k, giving you a right of appeal in relation to sentence, so that sentence would be set aside. Is that right?
Well, there's a number of things. Can I sort of take?
I'm not trying to.
No.
Force you away from it. I just want to understand what submission you're making.
My Lord asked first about the test in relation to 13.3k, and whether we were arguing it's a procedural matter. If one looks at the language of 13.3k, the language refers to measures of protection as are required by virtue of the status of being a minor. Now, that does suggest that, among other things, there can be, derived from it, what might be described as procedural rights to take certain things into account, because it's a measure of protection. That's the approach the Inter-American Court has taken to provisions of the same language. And in our submission, because that in particular reflects the language of the American Convention, those decisions of the Inter-American Court are important in interpreting it.
Right, but you might say the relevant measure of protection in relation to a sentence is just not to have whatever test one's going to use for excessiveness in relation to a sentence. You just shouldn't have an excessive sentence imposed upon you. So in which case, it's not procedural in the sense you seem to be contending for, but looks to the result.
Well, that's right. I mean, we need to come in one sense to the case law I'm referring to, and the materials that I'm referring to. But the approach in our submission that is clear in the materials is that in the context of a child, there are further factors that need to be taken into account: the welfare of the child, the need to ensure that the sentence is as short as possible. There are principles that apply. Going, though, on to the second, where my lord went, that's the first point from the question, what is the test? The test, we say, is, are there the measures of protection that have been identified as being required, particularly by the Inter-American Court, given the correlation?
So just to pin you down on that,
Yeah.
So you do seem to be saying that 13.3K is to be interpreted as a procedural right, even
As including the procedural right, yes.
All right, including, sorry.
Yes, sorry.
Even if you've ended up, in my example, with a low sentence, nonetheless, that sentence can be challenged if that procedural, the relevant procedural steps have not been gone through by the sentencing judge.
I mean,
Are you making that submission?
well, no. I mean, as a matter of domestic law, if the court of, suppose the Court of Appeal, which is perhaps what's most relevant, was to be faced with a situation where they'd had a trial judge who had a trial judge who'd disapplied the minimum, had said, this is the sentence I'm imposing, which was a very lenient sentence, but had done that without taking account of relevant factors that we would say need to be taken into account, in particular the best interest of the child. And the Court of Appeal look at the sentence and say, well, this was a failure to take account of the best interest of the child, but looking at this again, looking at this afresh, taking account of the best interest of the child, taking account of all the other relevant factors, the figure that you come back to is the same. It's difficult to see. I accept it's difficult to see what relief would then. I mean, it might be a technical breach of the charter, but it's difficult to see why any relief would be required, because there would be a fresh exercise that would be charter compliant, because it would take account of the best interest of the child. It would come to the same conclusion. I'm not suggesting in those circumstances that necessarily the sentence would, because it would make no difference.
Well, just trying to understand, if you like, the two positions that flow from 13.3K and 13.6.
Yeah.
Perhaps I can reframe my 13.6 and say that 13.6 gets you to the stage of saying that the minimum sentence becomes unconstitutional if that sentence constitutes cruel and inhumane treatment.
Yes.
Right. We can leave whatever test there is for that to one side. But as I understand what you say in 13.3K is that where you've got a child, full stop, you forget about the minimum sentence and you make an evaluation which is based on the best interest of that child, and there is no need to take into consideration the minimum sentence other than as an assistance in working out as where the starting points are.
Well, it's a guy. If you I mean, my understanding of how sentencing of a child.
Just looking at the minimum sentence, which is the thing that we're looking at here, that your submission is that 13.3K enables you to say that can be ignored other than as a sentencing guideline.
Other than the sentencing guideline, except as a sentencing guideline, it's relevant. But the problem, and it goes back to this, the problem which we submit is inconsistent with the rights of the child, is that any a minimum sentence, particularly of this nature, but any minimum sentence, is it prevents potentially the best interest of the child being taken into account, as would appear to be.
Well, I understand that's the reasoning, but the conclusion you want to that leads you to is that you ignore the minimum sentence provision other than as a sentencing guideline.
In relation to children, and I go back to the point I've emphasised, that this is not a general challenge to the mandatory minimum. It's a challenge to the mandatory minimum in the case of children.
And those are the tests that the sentencing judge in the Court of Appeal should apply when looking at this.
Yes.
Yeah. Okay.
I'm sorry to go back to my question. So just to be clear, and I'm just looking for a formulation from you.
Yes.
I think you've said that if the failure to take account of child-centred factors has not led to an excessive sentence being imposed, one wouldn't set that sentence aside. What is the test, do you say, if one's relying on 13.3K, at which one would say breach of 13.3K is such as to allow for the sentence to be set aside on an appeal, let's say?
To be sort of add some further clarity, hopefully, because we say one of the standards that's imported by 13.3K is the right to the minimum, to a sentence of the minimum period, if the sentence, having taken account of child welfare, is in excess of the minimum, then the minimum period should be imposed. That's.
Well,
sorry,
just to clarify, so in fact, my questions are not necessarily predicated on any minimum test. Children are sentenced for all sorts of crimes, many of which don't have minimum sentences.
Sorry, I realised as I was saying that I was using minimum in a slightly different way to the way we've been using minimum so far, and I was causing confusion. Obviously, the focus of the case is on the statutory minimum.
Yes.
The international human rights instruments that we've referred to refer to the need for any period of imprisonment to be for the minimum period appropriate, basically, so that a sentence should be minimised. When I was referring to minimum, that was the minimum I was referring to.
Okay. So that's what I'm asking you about. What test do you say should be applied, let's say, by the Court of Appeal, not in a minimum strict sense, sentencing sort of thing, but just an ordinary criminal case, where, let's say, the judge has been lenient but has failed to go through the mental process of looking at child-centred factors, but the result by the ordinary standards is on the lenient side. At what point, what is the test, do you say, for an appeal to be allowed if founded upon 13.3K?
Well, the approach in my submission is that the Court of Appeal needs to conduct a sentencing, effectively review what the sentence would be, taking account of the best interest of the child and the second principle I just identified, which is the need for the period to be the minimum appropriate. And I know that there's room for confusion, but I hope the Court now understands when I'm referring to minimum what I'm referring to there. If there's a difference between what the trial judge imposed and what you get to having applied those principles that we say are imported through the Constitution, then the sentence needs to be reduced because it's in breach then of those human rights standards which are imported. If there's no difference, then obviously...
Because in those circumstances, the usual restraint that the appellate court has on not interfering with the judge's sentence would be set to one side because the judge has made an error of law in passing the sentence. So the Court of Appeal effectively comes to the matter afresh and decides what the sentence should be without having to apply any grossly disproportionate or whatever test. It comes to what the sentence is. If it's the same, it's the same. If it's less, it'll be less. If it's more, then they probably stick with what the trial judge did.
I'd agree with that. Plus would add to that, of course, the Court of Appeal is bound also by 13.3K to apply...
Yes, I'm assuming that having identified the error of the trial judge and not having regard to that, they then re-sentence afresh, having regard to that.
Absolutely, but
so they could put up the sentence. You say it's just that they know those sentencing exercises. That seems to be the thrust of what you're now saying.
Well, yes, it is, subject to obviously that there are generally rules about not imposing an excessive sentence, not increasing the sentence. If you happen to be lucky enough to have got a judge who was overly lenient, and there's an appeal against that.
But on the wrong basis, you're in answer to my lady, you're saying, well, the judge just didn't apply the law correctly. So So why would there be that limitation? Why isn't it just a de novo sentencing exercise?
Well, it is it's, the reason why there may be, if you like, an upper cap set by what the trial judge set is that as a matter of sentencing practice, as a matter of humanity, it's generally recognised as being inappropriate to tell someone who's appealed, actually, terribly sorry, you're going to get a lengthier sentence. That's not necessarily derived from the human rights standards. It's just a matter of domestic sentencing practice. But the starting point should be that if you haven't taken account of welfare, you haven't taken account of other principles that apply, in particular the need to keep the sentence to the minimum, you have to reconduct that because that's your rights under the Constitution.
When you say the minimum, in the instance you're talking about, the UNCRC talks about the shortest appropriate period.
That's the language.
The Beijing rules talk about the possible minimum.
Yes.
But my understanding of a case like T&V, for example, is that you don't. They don't. Certainly, the European Convention doesn't require an exclusive focus on the best interests of the child. It's certainly not like family proceedings, so those are paramount. But you can have regard to the need, for example, for deterrence, punishment, the protection of the public. Those are, as I understand it, are all legitimate considerations. While you also, of course, have regard to, if you're dealing with children, you have regard to their interests. Now, the nub of the problem here is that you have a legislature deciding that it's necessary for the protection of the public and the deterrence of what in Jamaica is an extremely serious problem of violent crime, to have minimum sentences. And the thrust of your argument really is that minimum sentences are inherently unconstitutional so far as they apply to anyone under 18.
Well, that, I should say firstly, is something the UN committee has suggested in one of its general opinions, that there is a human rights prohibition on minimum sentences for children. The reason, and I don't resile. I mean, can I take my Lord's question to me in stages? Firstly, as I think we, probably by implication, have hopefully made clear in our statement of case, we don't suggest that best interest of the child is paramount. That's not the way we put our case, and we don't suggest that it's a sort of trump card, because obviously, if it were a trump card, you might argue that it prohibited the imprisonment of children generally, and that's clearly not right. However, the problem, in one sense, with a minimum is that it focuses on issues such as deterrent and doesn't take account of those welfare considerations. Now, we would recognise that the legislature has a role in terms of indicating where there might be said to be problem areas. So where there might be said to be a particular problem with gun crime, and it can do that by, for example, increasing the maximum sentence, which is clearly an indication to sentencing judges that the gravity of the offence it needs to be recognised. It can potentially do that. I mean, I had my Lord Steckland Morgan put to me whether or not the minimum would be acceptable effectively as a guideline, and as a guideline it may be of some relevance, because again it's an indication of how serious the offence is regarded by the legislature. Where we submit the constitutional problem arises is in this predetermination, because by predetermining it, essentially, the minimum, you are ruling out considerations which the Constitution require to be taken into account. So, my Lord, I hope that answers.
Oh, I'm sorry. Why do you say that? The Constitution talks about the right of every child to such measures of protection as are required by virtue of the status of being a minor.
Well, my Lord,
So, for example, there's a duty under that, I would have thought, to ensure that detention facilities for young people are appropriate to their age and make provision for education and so forth.
well, my Lord, it goes back to the point I made in response to a question from my Lord Sales. One has to recognise in our submission that language reflects precisely, as far as I can work out, the language of the Inter-American Convention. The American Convention. I always mistakenly call it the Inter-American Convention, the American Convention. And the American Convention has been interpreted, unsurprisingly, in light of the sort of near universal nature of statements about the need to take account of the best interest of the child, as incorporating that obligation. And so when interpreting a provision of the Charter which is clearly directly derived from the American Convention, one needs to take account of, for example, the opinions of the Inter-American Court.
So what's the measure of protection which every child has a right to that's relevant in our case?
Well, the measure of protection, it goes back to two things. The first and most fundamental is the one I just indicated, which is the right to have consideration given to your welfare as a primary consideration. And then secondly, I've used the word minimum, but at the shortest possible period. That second principle would derive from the UN Convention, the right to ensure the right to any period of detention being limited to the shortest possible. And that requires individual assessment. That's the fundamental point the UN committee makes, and I'll come to that material, is that those principles require individualised assessment. And that doesn't, just going back to where my Lord started from, T and V, that doesn't mean, I accept, that you can't say, as a sentencing court, or indeed as a legislature, that this is a crime that's of importance. As a result, weight needs to be given to the need to deter, for example.
Yes, I mean, it's worth reminding ourselves that T and V involved children of 10, and the imposition of an indeterminate sentence with lifelong liability to recall, even after release, was said not to be in breach of Article 3, having regard to the need for the protection of the public.
It wasn't, and that's in one sense why there's a key distinction between looking at, for example, what is a maximum sentence or what is an appropriate sentence in a particular case, and what is a mandatory minimum, because a maximum doesn't prevent account being taken of all the factors that we say need to be taken into account. A minimum does.
Yes. Well, that was a mandatory sentence.
It was a mandatory sentence, but of course, the penal element of it wasn't mandatory. And if I remember rightly, one of the violations, of course, of the convention was that needed to be set judicially.
Yes, that's right.
And that could be set at.
But that was I mean, this is a 15 years tariff imposed by Michael Howard. But that wasn't held to be a breach of Article 3, it was held to be a breach of Article 6, because obviously there was a lack of judicial independence.
I think it may have been Article 5, but my lord.
I think you.
Sorry,
it's curious. I was in the case, but yes. you have a better memory.
Yeah. It's funny how one gets the cases more that one's in, but the point I'm making, my lord, is that, and this is why I don't want to lose sight of.
No, I beg your pardon. It was Article 6.1.
Oh, sorry, my lord.
It was violated. There was a separate violation of 5.4, but it was for some other reason.
That's right. It was because of the parole board, my lord.
Yeah.
That the parole board it didn't have an automatic power. So my lord's memory is better than mine. So
yes.
But the point I was going to make, my lord makes the point that there was no violation of Article 3, and that's right. But that's one of the reasons why, in my submission, one shouldn't lose sight of the freestanding nature of Article 13.3k. I've made the point that Article 13.3k influences Article 13, Section 13.6, and that's still our position, and one should take account of that. But one shouldn't lose sight of the fact that there is that Article 13.3k is potentially broader. So.
Can I just ask this about what you're saying? I mean, you have accepted that the points Lord Reid put to you in terms of protection of the public, deterrence, retribution, and so on, are all relevant matters which can properly be brought into account in sentencing a child as they can in relation to other people. Where you get a legislature setting a mandatory sentence, mandatory minimum sentence, the legislature is not saying that sentence will be imposed on every child come hell or high water, because I think in answer to a previous question, you accept, as is clearly right, that you've got a minimum sentence here, but a maximum sentence can go up to 25 years for this offence. So it's not that the possibility of having regard to individual circumstances has been completely excluded in relation to this offence, because if you're getting to the really, really serious domains where you could get up to a maximum of 25, you're going to have space for an ordinary approach to mitigation to come into play. It's just that the legislature, having regard to protection of the public, need to send very clear signals, both to reassure the public and to potential criminals as to what is likely to happen. Thinks, having regard to the general factors, retribution, deterrence, and so on, that it's necessary to have a minimum sentence in place. Now, what makes it illegitimate and unconstitutional for the legislature to have regard to those sorts of points when setting a minimum, but leaving the maximum at large, or up to 25 years?
The problem with it is that the whole idea, if a minimum is to have any meaning, and we see this being applied in this case, it means that there will be cases where, on a normal conventional sentencing approach, less than the minimum would have been imposed. I mean,
sorry to interrupt. That's going to be true of adults as well.
Absolutely, but adults don't have the same rights, and that's why I'm focused to this extent on children. In the case of the child, whenever it's the case that the minimum is effectively going to kick in, that the minimum is going to determine the sentence, that prevents proper weight being given to the the best interest type factors that I've identified. Now, it goes back to the point that I made reference to this before, that my Lord Sir Declan Morgan made, which is, it's quite, if the legislature were to say, there is in the case of an adult, there is a minimum of 15 years, and that should be taken into account. The fact that there is that minimum in the case of an adult is a factor that should be taken into account when sentencing a child, because it's an indication of how serious we regard this. It's difficult to see, subject to any challenge there might be to the adult minimum, which isn't not something before the court. It's difficult to see how that's objectionable, because it's the legislature giving an indication to the sentencing court of the seriousness of the offence, but enabling the sentencing court then to take account of things the legislature simply can't take account of because it doesn't have the individual before it, which is the welfare of the child. The problem, at the risk of repeating myself, is that this effectively predetermines the outcome in cases, whatever the welfare indications may be.
So that the measures of protection which you identify as being included in 13.3K are not extended to that child in a case where, if they had been extended, the sentence would be lower than 15 years.
Exactly, lady.
And you're going to come to how you say we should read into 13.3K that those are indeed the measures of protection.
Absolutely, Milady. But just to be clear, I mean, in summary, it's primarily because that's how the Inter-American Court has done it.
And in which case has the Inter-American Court done that?
Well, it's done it both. I'll come on to the materials, but it's done it both in a general opinion and also in a Paraguayan case.
Well, the Paraguayan case was about preventive detention, not about sentencing.
But it applied the same principles as derived from the provision of the American Convention, which is in the same terms.
But that was in the context of preventive detention, not in relation to sentencing.
But it's the principles I derive from that.
Right.
My Lord,
No, that's all right. I'm just want to be clear.
You're going to take us to that in due course.
Yes, I will do.
One of the principles that you seek to garner from 13K, 3K, is the best interest of the child. Hasn't that been made absolutely clear by Section 65 at page 372
The 2004 Act.
of the 2004 Act? You don't have to go to the Constitution to see that the best interests of the child are to be taken into account.
Except, Section 65 is relevant to this extent, which is that, of course, it demonstrates that not only has Jamaica ratified the UN Convention, it has taken steps to implement it as a matter of domestic law. So it indicates that Jamaican society, for want of a better phrase, it recognises the importance of those principles. The reason I go to the Constitution is, of course, that if I need to depart from subsequent, I need to argue for a departure from subsequent legislation, and that's why I need to go to the Constitution for it. Section 65. If one didn't have the Constitution, Section 65 would be all well and good, but you would then have subsequent legislation which says there's a minimum, and Section 65 couldn't be applied.
So Section 65 helps you to some extent in the sense that since 1962, as a result of the international treaties to which Jamaica has signed up, and demonstrated by the 2004 Act, the best interests of the child are now have been recognised for some time within the Jamaican legislature, as it were.
Well, exactly, my Lord. That's the point I was making about how it shows that the UN Convention is not something that Jamaica's merely ratified. It's something that is meant to be incorporated into the standards of Jamaican society, effectively. Lord and my lady, I've obviously spent some time answering questions. Shall I go back to the structure of my submissions? And I think where I was dealing with the Court of Appeal's judgment, and the Court of Appeal, just in sort of passing in one sense, obviously its starting point was that the savings clause applied, but it did clearly go on to review a certain amount of material about international human rights standards as applied to children, and in particular, it considered the argument based on the South African case of the Centre for Child Law, which I will take you to at para 64, which is page 97 of the electronic bundle. It reached a conclusion, which may be of some importance, that although, and it goes to the point that was just being put to me, the legislation, the CCPA, stipulates that best interests of the child are a paramount consideration. That is not included in the Charter, and I'll come on to why we say it is implicit effectively in the Charter. And that led to the court concluding essentially it wasn't entitled to apply those principles, and we say that is wrong. Second point when looking at this case law that I would also draw attention to is that at 67, paragraph 67, which is electronic page 99, when dealing with the Canadian case of DB, the Court of Appeal indicated that in Jamaica, a child isn't given the right to opt out of an adult sentence. And Parliament has made essentially children subject to adult sentences. And that, in our submission, is obviously reflected in the legislation in question, which doesn't distinguish between adults and children at all. But we do submit demonstrates why this sort of legislation is problematic, because there is a need to distinguish between adults and children. The court, having effectively distinguished in particular the South African case law, which is most directly on point, based on those indications, went on to consider paragraph 82, compatibility essentially of the minimum with the Charter, and started at paragraph 82 onwards by looking at the CCPA again, which it indicated that the legislature had given due and important consideration to the vulnerability of children. The problem with that, and we don't dispute that conclusion, indeed it goes back to the point I made a moment ago and indeed was put to me by Sir Declan Morgan. We recognise the importance of the CCPA because it demonstrates how Jamaica has sought to comply with its obligations essentially under the UN Convention. The problem with it is that the CCPA obviously doesn't govern and doesn't require consideration of individual child welfare in the sort of sentencing exercise that is now caught by the statutory minimum.
The court appreciates clearly that the legislature hasn't replicated the CRC domestically, and says that it's done this to accord with our own Jamaican reality, which I imagine is a rather veiled reference to the the problems of crime well, it may be other things as well, but certainly that'd be one aspect of Jamaican reality.
But I mean, Jamaica has ratified the convention.
Yeah.
It has also...
it's a dualist system like ours, isn't it?
It's a dualist system like ours, and I'll come on to the relevance potentially of that. It's ratified the convention.
That's the point of this paragraph 82. You're saying even having dealt with the CRC adapted to accord of our own Jamaican reality, then even before that, Parliament would have been cognizant of the Beijing rules, and yet that principle has not been given special statutory force in Jamaica.
Well, the legislation is in the form it is, and we'll come on to that in a moment. The critical point, though, is that where Jamaica potentially has gone further is that it's also recognised the importance of child rights in its charter. And I mean, it's the legislation is obviously of some significance, as I already indicated, but it's not fundamentally. The starting point ought to be what are the rights effectively of children that are now incorporated into the charter, and there are those express rights, whatever they mean.
Can I ask, is there any Jamaican case law interpreting Section 13.3K?
Not that we're aware of, other than this, effectively.
Right.
I'm always very conscious of the dangers of saying there isn't something. It's a lot harder to know what there isn't than what there is, but not as far as we're aware. But I mean, ultimately, also, the approach of the Court of Appeal in relation to the minimum sentence essentially was to recognise effectively that there was a potential maximum of life imprisonment. Recognise that there was a potential maximum of life imprisonment, indicate that in those circumstances a sentence of 15 years wasn't grossly disproportionate, to use the language obviously which is found in the case law considering inhuman and degrading treatment. That, in our submission, is, in one sense, one wrong way of looking at it. The fact that there is a maximum sentence says nothing about whether or not it is appropriate, effectively, to impose that, whether it's consistent with human rights standards, to impose that in all cases. And indeed, the Court of Appeal recognised that there might be an issue with human rights if one looks at para 98. The Court of Appeal recognised that there might be a lack of conformity, to use its language, with modern pronouncements on children's rights. That, of course,
in relation to paragraph 84, the Court of Appeal appeared to be applying a test of gross disproportionality purely by comparing it to the maximum sentence.
yes.
And I understand you to be saying, well, that leaves out of account the individual circumstances of both the offence and the offender.
Yes.
But on a slightly wider basis, isn't the maximum sentence perhaps one of the factors to be taken into account in relation to determining whether something is grossly disproportionate, being the legislator's view of what the maximum is?
To that extent, yes, I wouldn't disagree with you, my lord, but one has to be very cautious about that, because obviously offences can vary massively. And so, for example, and I'm not planning to take you to this because of the fact that it's concerned with adults. It's not the focus of our argument. But for example, the Canadian courts have had concerns about minimums generally, and they've had concerns about that because of the fact that for many offences, you've got a very wide range of conduct. And so the fact that the maximum that may be required in sort of very grave cases is, say, life imprisonment, doesn't necessarily say what's required in cases at the other end of the spectrum.
The CC, I can't remember the precise terminology, the children's
CCPA, I think.
CCPA includes a maximum of 25 years for a child under 14.
Yes.
Did the Gun Act affect that in relation to children of that age? In other words, the sections quoted in the judgment seem to suggest that, notwithstanding what's in the CCPA, that for these offences, the maximum is imprisonment for life.
I haven't checked that.
I just wasn't entirely sure.
I haven't checked that. I'm going to ask my junior to double check the position in relation to that.
It's Section 8.1, I think.
Yes, what, of course, the Court of Appeal did, having, as I say, reached the conclusion that despite the fact there might have been concerns about consistency with human rights, the mandatory minimum applied, was it did go on to look at the sentencing, the sentence it would have imposed had there been no mandatory minimum, and obviously reached the conclusion that the minimum, that the sentence it would have imposed was 13.5 years. We have raised in our written case arguments essentially as to why, on the face of it, that approach doesn't necessarily properly reflect the need in particular to take account of the best interest or the welfare of the child. Because on the face of it, there is the application of an adult sentencing range. Age is simply taken account of as a mitigating factor, and a mitigating factor that is outweighed by the aggravating factors.
I thought that the age was also taken into account in fixing the starting point.
Sorry, you're right.
It was taken into account incorrectly twice.
Well, it's taken into account in adopting the bottom end of the sentencing range.
And it was taken into account again as mitigation.
Well, it was taken into account as mitigation, which was the point I was making. But it's still the application of an adult sentencing range. And what isn't there is any consideration on the face of it of the welfare implications. I mean, we would certainly submit that if you're going to take account of welfare, you need to look at, for example, the potential for the child to be rehabilitated.
In this jurisdiction, is there such a thing as a minor sentencing range? In the sentencing guidelines, do they distinguish between adults and minors in the sentencing ranges that are prescribed?
Well, my understanding of the way the sentencing guidelines work is that you start from the adult sentencing guidelines, but you then apply a child sentencing guideline, which then says, depending on age, for example, I think if I'm talking from memory here, but I think if you're 16, it's sort of meant to be roughly half, if I remember rightly, the guideline, so that there is. The position is slightly more complicated in the UK, and the sentencing guideline is effectively modified by the overall guideline that applies to children. So, in other words, if a sentencing judge dealing with someone who was from memory, if a sentencing judge in the UK, or certainly in England, was to deal with a child who was 16 at the time of their offence, and say the adult guideline is 1 to 2 years, for example, I'm going to apply that. This is, but because of your age, I'm going to put you at the bottom end of it. That would be wrong. What the English sentencing judge would be required to do is say the sentencing range is 1 to 2 years, but because you're 16, I am reducing those periods. We have in the bundle partly for other reasons, well, very much for other reasons, we do have the overarching English guideline in relation to children.
But was that applied at all by, I mean, I see reference to the sentencing guidelines for use by judges of the Supreme Court of Jamaica. Presumably they have their own.
They have their own.
Sentencing guidelines, which we don't have.
Yes, the reason why we have, well, the case, it's in fact, I think, if I remember rightly, derived from authority. It's not a sentencing guideline, that's right. It refers to an authority which is described as, the case of Kerry Scarlett. So it's sort of an old-style judicial precedent rather than what we would recognise as now and what English lawyers would recognise as an authority. I should make it clear, the reason, just to be absolutely clear, the reason why we've included the sentencing guidelines from England is not because we say that they are in any way applicable, but it's because they identify the reasons why children are different and consistent with the approach of in fact, other jurisdictions. They make the same points about why children are different. I mean, obviously the final sentence that would have been imposed, but for the minimum, according to the Court of Appeal, was 12 years and 10 months. And obviously that is significantly different to the sentence that was actually imposed.
The minimum sentence.
Yes.
Is it right that that always has to start from the date of sentencing without taking into account time spent in custody, or does it take into account time spent in custody?
As I understand it, it doesn't take account of time spent in custody because Jamaica, well, on the approach of the Court of Appeal, Jamaica, as indeed in England was until relatively recently, is a case where is a jurisdiction where you need a judicial decision as to what is taken into account.
Yeah.
At the period that's taken into account.
Yeah, I don't know what the situation is in Jamaica, but the thinking used to be in this country that effectively remand in custody was the easy option, and it was better to effectively serve your sentence on remand than as a convicted prisoner. And so, in order to discourage people from withholding pleas of guilty, which were inevitable on a sort of rational view, you didn't encourage them by not backdating the sentence.
Yes, but even, I mean, relatively recently, the practice obviously in the English Crown Court was that a judge had to order a period spent on remand to be taken into account. I think that changed probably within the last 5 years. And that had become automatic, but it caused huge confusion because of the fact that judges often didn't get reliable information about the period that had been spent on remand. And there was a whole series of cases about how one needed to have a sort of, use a phrase, a form of words that allowed the administrative staff then to change the sentence to reflect the true period. So
do you know what the present state of your clients' whereabouts are?
I've asked for instructions on this. I haven't yet. I asked a few days ago, but I haven't received instructions back.
You may well be on parole at this stage.
I don't know. That's one of the reasons why I asked for it, because I did the maths and I asked for instructions on it. But if I get instructions, I will tell you. But I haven't been able to obtain instructions yet.
Would your junior be kind enough to please provide the statutory provisions that in Jamaica that actually set out what it is, what the rule is about sentences, whether they start from or take into account the period that has been spent on remand.
Yes.
And but you're clear that the period on remand is taken into account, is that right?
Well, the way in which it was imposed in this case, which we understand is lawful, is that, well, the way it would have been imposed, but for the minimum, is that there was a conclusion was reached about the way in which the sentence that would have been imposed had there not been a period of remand, and then the sentence was further reduced to take account of the period on remand. And that's the way we understand sentencing works in Jamaica.
If I could have the actual provisions.
Yes.
But as I understand it, you say that the sentence of 15 years doesn't take into account the period that was.
That's right. Yes.
Yeah.
That's.
And that's because you're not permitted to, because it is a minimum sentence.
It's because it's a minimum sentence.
Yes.
And the minimum sentence speaks from the day it is uttered,
Yes.
and as opposed to being backdated.
Yes.
Well, I would like to see the
Yes,
legislation.
we'll confirm that with getting the legislation, but that's what we understand, not least because of the exercise that the Court of Appeal purported to undertake had it not.
Because I think Mr. Knox says something different. I think he says that a period spent on remand can be taken into account in calculating the minimum period. But anyway, yeah, I think that's really just to ask for assistance from both sides so that we can understand that.
Okay, well, I'll speak.
While we're asking for assistance, I mean, paragraph 100 in the Court of Appeal, they refer to the December 2017 sentencing guidelines. Do we have those in the bundle?
No.
I think we'd better see those since the court itself is referring to them. And also, were there sentencing guidelines in place in May 2013 when the appellant was in fact sentenced?
We'll double check that as well.
Yeah, we better have those if they were.
Can I then turn to the provisions in issue? Obviously, the 2010 Amendment Act is the provision that provides for the minimum. It is at page 362. And 2 points about it, really. Firstly, there's no doubt, as I've already indicated, that it applies to count 3 in this case. And secondly, it is clear that it doesn't distinguish between adults and children. That has obviously now been amended further by the 2015 Act, the Criminal Justice Administration Amendment Act, I think, of 2015, and that's at page 398. That wasn't open to the Court of Appeal to apply in this case by the time the Court of Appeal heard it because of time limits within it, but it provides essentially for a procedure that allows ultimately the Court of Appeal to reduce the sentence imposed if initially the trial judge is the opinion that the sentence is manifestly excessive and unjust. But it still probably, most importantly, results in a minimum sentence of 2/3. One sees that at page 405, and that's section 42K 2B.
Well, I wondered about that. Right.
Can I ask, when this mechanism is operated, does the Court of Appeal judge apply the same test of manifestly excessive and unjust, or a different test?
As far as I'm aware, it is the same test, and the reason it's the same test is if one goes to page 406. Oh no, sorry, it's page 405 for the 406 is dealing with the sort of the historic sentences. 405. If one goes to 405, 42K3, condition precedent, essentially, for the imposition of a reduced sentence is that the Court of Appeal agrees with the decision of the court and determines there are compelling reasons that would render it manifestly excessive and unjust.
Right, so that does look like the same test.
Yes. And that, just to be clear also, one of the reasons, presumably, for that is that in the case of the historic cases, and that's the reference I was about to take you to, which is 42L, the ground that you apply to the Court of Appeal on is whether the sentence was manifestly excessive and unjust. So it would be sort of surprising if the Court of Appeal were not applying that test when it has its own first instance jurisdiction where it applies that.
You were going to point us to where the 2/3 minimum.
Sorry, the 2/3 going back to 405. It's if one goes to 42K, so 2 actually it's 3. 42K 3B.
Oh, yeah.
One sees.
Isn't that setting the period of parole? The A sets the period of imprisonment, and doesn't B set the period of parole?
Well, now, if you read
the Court of Appeal said it was that you couldn't go below 2/3. But I just wondered about that.
I mean, 3A refers to the sentence imposed,
Yeah.
defines the sentence imposed, and 3B is based on 2/3 of the sentence imposed by him.
Yes.
To be a parole provision.
I mean, the reason I hadn't noticed that, and the reason I think the Court of Appeal
I mean, it might be true if the sentence imposed by him was a reference to the sentence originally imposed by the trial judge as the minimum, but that would be very odd.
yeah.
And surely 3A is saying that the judge of the Court of Appeal imposes a sentence.
That's right.
Yes.
And it seems that his sentencing discretion is at large, is just given the power to go below the prescribed minimum.
Yes, I think that might be right. I mean, I think I'd proceed on the basis that the Court of Appeal were correct, but I think that may actually be correct, that it's actually about parole minimums rather than.
It would be very odd to say it has to be manifestly excessive, but then it still has to be 2/3.
Well, except I think if I'm right that in the South African case that was under challenge, certainly one of the either the South African or Canadian cases, there was a situation where there was a power to disapply the minimum, and then you still ended up with a second minimum, basically. So it wouldn't be sort of unprecedented. Certainly there is reference in one of the cases that we've been. I can't off the top of my head remember which it is, but.
Does this legislation require a first instance judge to impose a sentence which is unconstitutional because it's grossly disproportionate? And if that's the right test.
Well,
and therefore itself is contrary to the Constitution.
I suspect the answer to that may be that if by triggering the provisions of Section 42K, you effectively, as a trial judge, sort of continue the procedure. You don't bring the procedure to an end. In one sense, the answer to that maybe it's not unconstitutional on that basis, because ultimately there is effectively the procedure, an ongoing procedure, and the ultimate question may be what the outcome of the Court of Appeal application is. So I don't think it's our case that 42K is inherently unconstitutional by requiring the imposition of a manifestly excessive and unjust sentence because the sentencing procedure effectively hasn't come to an end.
Right, but the sentence is still being imposed. I mean, the use of the language here suggests that at least the drafter thought that imposing a sentence, even if manifestly excessive and unjust, would not be such as would offend against the inhumane and degrading treatment limit in the Constitution.
Well, I mean, one would assume the drafter believed that what they were drafting was compatible with the Charter. So if they believe what their drafting is compatible with the Charter and they understood the potential significance of a sentence that was grossly disproportionate in Charter terms, the answer to that would presumably be that they regarded the mechanism of an appeal as sufficient to then save the sentence or the sentencing procedure. And
I only call attention to it because it seems to me that it goes back to a point that Sir Declan Morgan raised early on in the hearing about the difference between a test of manifestly excessive, which is the regular appeals test, and what one might think was the significantly tougher test of inhuman and degrading treatment. And this tends to suggest that at least the drafter of this legislation may well have thought that there was a difference and a gap between those two.
Well, I think, hopefully, I mean, I've indicated what our position in relation to it is, which is that the drafter may well have thought that compatibility, I mean, even if that's right, there was clearly the potential for within the manifestly in excessive, even if it's manifestly in excessive, is a wider group than grossly disproportionate. Within that group, there will be potentially grossly disproportionate sentences, and presumably, if the drafter was intending to comply with Charter obligations, the drafter was the opinion that by having this additional sort of procedure in place, those sentences could be saved. And
I just don't understand how a judge can impose a sentence if the test for inhumane treatment is grossly disproportionate. How constitutionally a judge can impose such a sentence.
well, maybe I'm arguing against my own interests here in trying to save this provision, but the point I mean, the way in which I understand it would operate in those circumstances, I mean, whether or not there is a difference between manifestly excessive and unjust, in principle, it may be that a judge reaches a conclusion that a sentence is grossly disproportionate. Now, if they reach that conclusion, presumably, what they're required to do, because they know that there is, in one sense, a safety valve, is say this is not only manifestly excessive, it's a grossly disproportionate sentence, but I'm compelled by the minimum penalty provisions to impose it, but I'm satisfied that there is a safety valve, which is that as a result, this case will go to the Court of Appeal.
I mean, I would have thought that the debate would occur before the trial judge. The sentence you're proposing to impose is in breach of my constitutional rights, therefore you cannot impose it.
Well, all I'm suggesting is that there is, I mean, that from the trial judge's point of view, that there is what might be regarded as a safety valve. I mean, I'm not sure where it takes us, whether or not the trial judge is, I'm not sure it takes us very far, in one sense, whether the trial judge is technically in breach of the Constitution by imposing the sentence, whether the trial judge, as a result, disapplies that. I mean, the fact of the matter is that ultimately, from the individual's point of view, what they're concerned about is what the Court of Appeal does, and the Court of Appeal has the powers that it has. turning then to the Constitution, and I'm going to refer to, because it's consolidated the Constitution Project version of it. I hope that's satisfactory.
Can I get? I'm sorry to interrupt, but I see that the Court of Appeal took the test of grossly disproportionate from the case of Gangasingh Albiluk, a Mauritius appeal to the board.
Yes.
We don't have it in our bundle, but I'm looking at it. It's a case where Lord Clark gave the opinion of the board back in 2010.
I think we do have it bundled.
It's in the bundle, yeah.
Yes,
well,
we do.
Right. Well, I'm grateful. It refers to quite a lot of earlier authority, including in particular Lord Bingham's judgment in Reyes, R-E-Y-E-S, which does seem to support the test, but the principle is identified in paragraph 32. Well, the principle that the board thought was right was one that Lord Bingham had taken from the judgment of Mr. Justice Lemaire in a Canadian case under their charter, where he says, well, the test is whether it's grossly disproportionate. He says this doesn't mean that the judge or the legislator can no longer consider general deterrence or other penological purposes that go beyond a particular offender in determining a sentence, but only that the resulting sentence must not be grossly disproportionate to what the offender deserves.
I'm so sorry, which paragraph?
32.
Thank you.
Paragraph 32.
Page 833.
Yeah.
So you can have regard to a range of penological purposes, and a legislator can do that as well as the judge. And you don't have to confine yourself to the particular offender, but the only constraint is the resulting sentence must not be grossly disproportionate to what the offender deserves.
It goes back to the point to make about that's in the case of an adult, and we don't dispute. We've never suggested otherwise that is the correct approach in relation to an adult. The question is, where does how and where does the specific status of, or the specific interests of children fit into that? Because all of this case law is effectively considered the position of adults. And that's...
But that's really the answer to the point I was raising with you earlier about the grossly disproportionate test being quite different from the Strasbourg approach to Article 3, and the answer to my objection is, well, the board has approved this over many years. It's established jurisprudence.
Well, can I go back to the convention, the Constitution? Page 292 of the...
So, sorry, just to say so have we got to the stage where this grossly disproportionate wording is how you test whether a punishment amounts to inhuman and degrading treatment?
Yes, as a matter of... yes, and certainly in relation to...
That's dealt with by Lord Clark at paragraph 21. He says a literal reading of the Constitution does not immediately suggest that is the correct approach to it, the grossly disproportionate test.
Yes.
Which is perhaps putting it mildly. But he says, and gives an example, that the prohibition against subjection to torture or inhuman or degrading treatment might be read to refer to something much more severe than the 3 years penal servitude in the present case. However, the DPP accepts, in the Lordship's opinion correctly, that the effect of Section 7 is to outlaw wholly disproportionate penalties, and then they then go on to refer to the authorities that support that approach.
And that's why the Crown here recognises that the exercise that the Court of Appeal did in this case was legitimate as far as it went.
Yes.
And it also accords with Vinta, isn't it?
Yeah.
Yes, I mean, I think in fairness, on the written cases, as I understand it, there's no dispute between the parties that ultimately grossly disproportionate is the test. And also, to be clear, and I think I said this in relation to a question from my Lord Reid earlier, grossly disproportionate allows account to be taken of, for example, the seriousness of the offence, and we don't dispute that.
And the circumstances of the offender.
But also the circumstance of the offender, yeah.
And we also think that grossly disproportionate is something more than just being manifestly excessive. If manifestly excessive is the general test that a appellate court applies when reviewing a sentence. So grossly disproportionate is a subset, one might say, of something which is manifestly excessive.
I don't think I've conceded that, partly because I raised the point before, which in one sense is the grossly disproportionate has generally been, well, has been raised in sort of human rights litigation where there's been a challenge to a sentence that's been held to be lawful for other reasons. The concern I would have is if you go the other way round and say this is a sentence which is unlawful as a matter of domestic law, it's difficult to see how that isn't. One could argue that that is grossly disproportionate because domestic law effectively sets the standards. But I'm not sure where that takes us.
Well, I don't think that everybody who has their sentence reduced in an ordinary appeal on the basis that the sentence passed was manifestly excessive can then bring a claim to say that their human rights have been violated.
Well, they can't, not least because of the fact, of course, the Court of Appeal has corrected the sentence. So,
but it may not do so. A sentence is imposed when the trial judge imposes it.
yes.
So if, in doing that, the trial judge was imposing a sentence which the Constitution did not allow the trial judge to impose, one would expect there to be argument before the trial judge saying, you cannot do this because it breaches my constitutional rights.
Yeah.
Yes.
I mean, for example, a custodial sentence might be imposed in circumstances where it was manifestly excessive, and the person may then have served time in custody before the sentence is quashed.
If you equate the tests of inhuman and degrading treatment, which is gross disproportionality according to this and other authorities, with the domestic manifestly excessive test, aren't you in fact going to lead to arguments being introduced at the trial stage directed to these sorts of issues, which would more naturally be arguments for the Court of Appeal on an appeal applying a distinct manifestly excessive test?
I'm not sure I'd accept that, my lord, in the sense that ultimately, even if I'm right, the focus, because I'm saying that domestic law in some senses provides added detail, provides the detail of the standards protected by human rights law. If an individual is seeking to appeal, they are likely to focus on whether or not the sentence is unlawful as a matter of domestic law. The only question I'm raising is whether, in circumstances where it is then concluded that as a matter of domestic law the sentence was unlawful, whether or not in those circumstances it's possible to say that the sentence is grossly disproportionate because it doesn't meet the standards. Domestic law has said this is effectively an unnecessary sentence.
Yes, thank you.
There are also procedural implications. I mean, for example, if every appeal against sentence is raising a point under the Constitution. There's probably an appeal of right to this court in every sentencing appeal in Jamaica, and indeed in our other jurisdictions.
In one sense, that's not my problem.
I know it's a fiat justitia ruat coelum point.
Turning then to the Constitution, and page 292, just draw attention to Article 2 because it makes it clear that the Constitution is essentially paramount. It prevails over any other law. Subject to sections 49 and 50, as I understand it, 49 provides for amendment, but wasn't applied in this case. I mean, there is a procedure by which it is open effectively to the Jamaican Parliament to say we are going to disapply, we're going to pass this legislation despite the provisions of the Charter, but that procedure wasn't adopted in this case. Article 50 is now repealed according to the version we have. The Charter then is at page 296. And starts by setting out the context effectively of the provisions of the Charter. It effectively identifies the reasons why, or the basis on which the rights set out afterwards, after that provision, have been enacted. 13.3, and that's where there is the reference to the inherent dignity of individuals. 13.3k then is the rights of, deals with the rights of children, and we've I've already made reference to that and the terms of that. It is clear in my submission that it is intended to give specific rights to children, not least because if one looks at 13.3k2, one sees actually quite a detailed right, which is in relation to education. That language, though, is important to note because we'll come to it, but in our submission it does reflect the language of the Inter-American Court, the American Convention, rather, on the rights of the child. Then one has, as the court's made reference to, 13.3.0, which is the right to protection from inhuman and degrading treatment, and 13.6. Which effectively repeats the right to protection from inhuman and degrading treatment.
Why is it repeated in that way?
I have to say I'm not entirely sure. I've wondered about that, and I don't have an easy answer to why that is repeated, my lord. It may be that it was a drafting technique to ensure that it was clear that the savings clause effectively applied simply to that right. But I don't quite understand why you wouldn't. It wouldn't have been identical. The position wouldn't have been identical if 13.3.0 had simply said subject to subsection 7.
But the fact that it's in O then brings it within within section 2, which makes it subject to sections 18 and 49 to subsections 9 and 12, and save owners may be demonstrably justified in a free and democratic society, because the top bit of 3 lists the rights and freedoms which are referred to in that subsection.
That's right, my lady, and I'm not suggesting you couldn't. It would have been if you just dispensed with own, you wouldn't. That wouldn't have a consequence. I mean, what you see in 13.3 effectively is a list of all the rights, and some of them are expanded upon. So that, for example, there is reference to the. If I remember rightly, yes, 13.3a refers to the right to liberty, which is then expanded upon by 14. 14 is where there's detail about the right to liberty. The odd thing here, as I say, is not that it's placement in 13.3.0. It's that, as I say, if 13.3.0 had simply said, effectively, it was subject to 13.7, I'm not sure what implications that would have had. You could, on the face of it, potentially get rid of 13.6. That's where I've struggled. One point I'd make about the context of this as well is that this was, as is clear from the various statements of case, this was enacted in 2011. It was, obviously there were, and because of the position on savings clauses, I don't really need to go into detail, there were rights in much more general terms protected by the earlier version of the Constitution. That's of a limited significance in the sense that what in our submission is clear is that this version was intended to enhance rights, and that earlier version was reflective, to some extent at least, of the European Convention on Human Rights, as my learned friend fairly accepts. So there is a sort of indirect linkage between this and the European Convention on Human Rights. I'm not really going to focus on the European Convention. I'm focused much more on the inter-American system, but it's not inappropriate for us to make reference. We would submit to the European Convention. The principles then of interpretation of the Constitution are well established and clear. There is no dispute between the parties that I don't think that, firstly, as, for example, recently identified in the Ferguson case, which is at page 655 of the authorities bundle, firstly, that this court will interpret an ambiguous enactment in a manner consistent with international obligations. I should say ambiguous in that context, and I'll give you an authority for that in a moment, is quite clearly a provision that can be read in one of two ways. And so if it can be read consistently with human rights law or inconsistently with human rights law, it should be read consistently with human rights law. Secondly, it should be given a generous approach. And thirdly, that the European Convention can be relevant, not least because it is an antecedent, and it's an antecedent we would submit in Jamaica. One key principle, which may be of some relevance, although I have to say, given the position on savings clauses, we sort of question how relevant it is what might be described as the living instrument principle. It is the need to ensure the application of contemporary standards, as was made clear, for example, in Boyce, in particular, which is at 766. Boyce is significant because it gives greater detail, really, about the approach to interpretation, and makes the point, as I've already indicated, that ambiguous has this particular meaning, which it means that something is capable of conforming or not capable of conforming. But it also looks at the approach, essentially, to both international instruments and the changes in standards. And paragraph 26 of Boyce, which may be worth going to, which is I think page 766. The court emphasises or makes the point that the principle that I've just identified, the principle that ambiguous clauses should be identified consistently with human rights law, is strongest when law is intended to give effect to a provision of international law. That, we submit, is important, particularly in relation to the American Convention, where the American Convention obviously predates the Charter and the language is the same. It refers to it being more difficult in relation to subsequent provisions, but as I've already indicated, we struggle to see, although that features heavily in my learned friend's written case, we struggle to see, once it's accepted the savings clause doesn't bite here, how that's of relevance, because of course all of the treaties that we refer to were ratified by Jamaica prior to the Charter. The Charter is more recent. It then, in any event, looks at the way in which standards can develop at paragraph 28.
If we're going to go further into the judgment, perhaps we might do that after the adjournment.
Thank you. Certainly, my Lord.
Very well. You'll have to bear in mind that the time remaining to you is...
I am going to, yes, I'm very conscious of that, and I'm very conscious of the fact that in answering questions, I think I've covered a number of the areas that I need to cover.
Yes, we haven't wasted time. We should have gathered the judges had done their homework.
No, absolutely.
We've made some progress.
Yes.
Thank you.